If a trust should not be an owner of an annuity, should it be the beneficiary? And the general answer, and that's a general rule with many exceptions, is still no. Because once it's the beneficiary and you die, it's now the owner. And we still get all those problems. So it's my general rule, and I always look at the circumstances to decide if we're going to deviate from it, is that people should be the owners and beneficiaries of annuities. Because people have life expectancies, and we can stretch out the annuity. What sometimes happens is the trust, which doesn't have a life expectancy, but also won't get the annuity, has to pay the tax on money it never saw. We don't want that. So that's something to think through in terms of the kind of annuity you have and what it's going to accomplish. But as a general rule, annuities are not good choices to be owned by your trust, now or at your death. If I have a financial power of attorney, how is that different from having someone named jointly on my bank account? A financial power of attorney is usually always a good thing. First off, because of those issues I talked about by putting someone on your bank account. Okay, but even if you decide to name someone jointly on your bank account, you want to have someone who's going to be able to go to the post office and close off your your mail and things like that won't really be handled by your bank account. The other thing is, though, be careful that your power of attorney is not too simple. I have seen one-page powers of attorney, and banks don't like powers of attorney. Because you know what? What happens if I name Peggy as the agent of my power of attorney and Peggy goes and steals all my money and moves to the Bahamas? Who is my family likely to sue? The bank, because they've got a lot of money, and Peggy's too far off there in the Bahamas. So banks are really anxious not to be screwed with that, and so you've got to be careful. But powers of attorney are one thing you need to deal with. And I would recommend that you pretty much have one if you've got any property, even a car, and the furnishings in your house. Because how do we get rid of those things if you're sick? The question was, can you have insurance in a trust? And the answer is that's usually no problem. Insurance can be a really good asset to be in different kinds of trusts. Mm-hmm. Is there one piece of paper that covers all the bases? No. Because even with a living trust, it only covers stuff, okay? And then you still want the things that deal with people, medical powers of attorney, stuff like that, and trusts never do that. So there is no one piece of paper that can cover everything. Which is why, you go to a lawyer, and they call them all kinds of different pieces of paper, but as far as you're concerned, you got the plan. And that's really what you were after. Even if it felt like you sold your house by the time you signed it off. The question was, if I have a piece of property outside of the state, and I put it in trust for my son, and then I decide to sell it, can I do that? And I'm going to give you the typical lawyer's answer. It depends. It depends on what the trust says. Okay? Having out-of-state property in a living trust is a very good idea, because probate is a state proceeding. So if you die here in Colorado and you own a property in Texas, we're going to do two probates. One in the state you died, and then what's called an ancillary or mini probate in the state where you own property. So you want to put it in a trust. But if you said, what you said was, for my son, if your son is already a beneficiary, if you're the trustee, you can certainly sell it, but you may not be able to take all the proceeds because he's also a beneficiary and you're taking care of it for him. So it would depend on how the trust read to tell you what your role was and what the limitations, if any, were on that role. You need to appoint someone as an agent under your power of attorney while you're reasonably healthy. Powers of attorney come in two flavors. One is an immediate power of attorney, which means that the minute I sign a piece of paper giving Peggy authority under my power of attorney, Peggy can be me in all legal affairs, which means she can go sell my house and not tell me that the movers arrive. Okay? That may not be what I want. But I may want to say, Peggy, if I can't act, I really need you to be my surrogate. That's called a springing power of attorney. In this case, it would spring into effect when I'm disabled. Now, here's a biggie, okay, because I see this a lot. If you look at your power of attorney or your living trust, because it happens in living trusts too, who's going to become the successor trustee when I become disabled, right? You should have that in there. The problem I've seen in those is it says, when I become disabled, comma, Peggy should be my successor trustee. How do we know I'm disabled? If I'm in a coma, I guess that's pretty easy. What if I'm just kind of having a bad day? What if I have Alzheimer's and there are good days and bad days? What if I'm the cat lady and I just won't leave the house? I mean, what's disabled? So that's a really scary one to me. So you should look at your documents and make sure that you have a definition of your disability. It might be as simple as 2 doctors have signed a piece of paper saying I can't manage my own affairs. It doesn't have to be. You could say I want my spouse, my doctor, and my children and my pastor to decide as a committee. This is one of the few places where I like committees. I don't like them generally. But to decide as a committee, yes, I'm disabled, no, I'm not. My fear is that some doctor, because they're as human as the rest of us, is going to look at me and go, you know, she's kind of anxious, she moves around a lot, she moves her hands, I think she's got a problem, and guess what, she's disabled. This is really weird. Well, if you talk to my family, they'd go, what's new? It's not a question of what's weird, it's what's weird even for me, such that you should take the reins away from me, right? No problem with being weird. So the answer is you can do a power of attorney, and I suggest you do, but it doesn't do anything, doesn't spring into effect until you need it. The question was, who's monitoring the use of your coupon? Who's monitoring what you gave away and what you didn't? Nobody. That's a self-reporting part of our tax system. Okay, but when somebody signs your tax return, when you die, they're going to say, no, there were no gifts, or there were gifts, and they have to tell the truth. Or they're just going to find there's a problem later if they ever get caught. So that's what we're talking about. It's a totally self-reporting system, but a lot of penalties if you don't report correctly. How does a payable on death designation, or you'll also see it as a transfer on death, so POD or TOD, fit in? That's like naming a beneficiary of like a bank account or a brokerage account. It doesn't change the fact that you own it and control it while you're alive, but you've already decided who gets it when you die. Again, you can change your mind anytime you want, and it won't go through probate. So that's another way to deal with that. The thing with payable on death beneficiaries, transfer on death beneficiaries, is it's going to go straight to Derek. It's not going to go to a trust for Derek. That's also the thing with beneficiary deeds, right? I want to name, now I'm going to give myself 3 kids, heaven forbid. But if I've got 3 kids and I name all of them on my beneficiary, and one of them wants to keep the house and 2 of them want to sell, what do? I haven't solved that problem. I haven't put in even a personal representative in charge of making that decision. I've just given them each a third. So unless we've got, maybe my 2 could agree, I don't know, depends on the day. But we really have to think through what we're doing when we put them in that situation. You see how it all goes to what you want and what your family's like, and I can't give anybody the same answer. It's not about a cookie cutter. What are some of the issues surrounding blended families? Oh, okay. Well, let me tell you about one of my big passions in estate planning, and that's the stuff. Okay? It's easy enough, if we've done even some basic planning, to say, okay, we sold all the property, there's 5 of you, there was $100,000, here's a check for $20,000. But what do we do with the sideboard that was at every Thanksgiving dinner, and all 5 of you want it? Okay? Or we do with mom's wedding ring. Or what do we do? Sometimes it's things that have value, and sometimes they have no monetary value, but everybody wants them. Or enough people want them. See, you're all nodding your heads, because we've all seen this. Okay? Even in my extended family, where I thought these people would never be like that, they were. Okay? So what in your family, whether it's blended or not, I really suggest that you look at your documents and don't let it say, divide all my personal property equally. Because I don't know what equal means. When we all want the sideboard, how do we take a chainsaw and divide it in 5 pieces? So I actually have a workbook that I give to clients to help them work through what they really want to accomplish. And in the end, they give me a process. It might be, I know I've listed these 10 things on the things I want my kids to have and who gets it, but there's going to be something that's not on the list, right? There always is. So what do we do with what's not on the list? Do we say they have to flip a coin? Do we say we're going to have them each pick something going from oldest to youngest or youngest to oldest? Do we say we're going to give you each $1,000 in Monopoly money and you have to bid on it? Do we say you've got to bid on it with real money? There's all kinds of ways to go about it. But if you, as the parent or the person who had the property to start with, gives them a process